11:30. So I would remind our last two panelists that they should keep their remarks a maximum of 30 minutes, and if they can cut back a little bit, that would be good, because it is important that we have some time left for your questions and comments. Darren?
Thank you, John. Good morning, ladies and gentlemen. May I first add my thanks to the other panelists who've spoken today and yesterday, to the very kind and generous hospitality that's been extended to us by the US Naval War College. And I must say, as an advertisement, the International Institute of Humanitarian Law, whom I'm one capacity representing here today, is very grateful for the relationship that it's been able to develop over the years with the US Naval War College, and in particular the support which it's received from the US Naval War College in the conduct of its courses. And being able to co-sponsor this event is seen by us as just a very small means by which we can pay back that debt of gratitude that we have to the US Naval War College, and a relationship we hope will continue on into the future. As I said, I am here as the Director of the Military Department of the International Institute of Humanitarian Law, but as usual I have to provide the caveats that I am not necessarily providing the views of the IIHL. Indeed, Professor Dinstein, who's on the council, as well as Professor von Heinig, will correct me if I would cut across the neutrality principles that the IIHL hold dear to its heart. Nor do I represent or speak on behalf of Her Majesty's government, but having said that, I am a serving officer in the British Army, and so as a consequence, and as is required under British Army rules, I've had to have my comments vetted. In that sense, the non-controversial aspects of my presentation, I'm afraid, are an enforced requirement on me by the British authorities, but such is life in terms of serving in uniform. My thoughts, in terms of personal thoughts, will be based upon my experience as an operational military lawyer, and I know there are many colleagues in the room who've had similar experiences. And in that sense, I apologize in advance to the academics in the audience if I occasionally try to simplify matters to that of what the common soldier will try to understand. I am a simple soldier, and I state that right from the start in terms of the approach that I adopt, and also my attempts, feeble as they may well be, to try and reduce the debate into bite-sized chunks I can actually understand. And I have to admit that on many occasions I leave conferences like this with a serious headache, not based upon the frivolities of the previous night, but more the fact that my brain seems to be banging around the inside of my skull from trying to understand some of the blue sky concepts that are occasionally articulated. Having said that, I will steer clear of some of the comments that have been made by colleagues on the panel this morning, particularly in relation to the jus ad bellum debate. Although, if you'll indulge me for one moment, again being a simple soldier, the ships will always pass in the night if their start points are from entirely different areas and they are tracking entirely different routes. So, for example, I think we've seen today a good case of the debate which is going on constantly at the moment, and that is in terms of the self-defense or Article 51 argument, which is actually inherently a jus ad bellum argument, and where that particular argument is then approached from the opposite direction by a self-defense argument based on a human rights platform which talks about individual self-defense, and those particular ships will always pass in the night and not come into contact with each other. And I think in some senses we've certainly seen elements of that in the way in which this particular debate over the use of drones is shaped. In addition to that, and if I may as an outside observer, comment on the significance of Mr. Coe's statement with respect to the ASIL conference. Certainly from the view that I have taken as an observer, an interested observer of course, is that his statement is significant in that it defines what the current administration's views are on the extent to which it will exercise self-defense under customary law or in accordance with the the UN Charter. And that's informative and relevant, particularly in relation to the debate concerning the use of drones in Pakistan, because it reinforces, in essence, the elements of sovereignty as being a key issue in terms of this entire debate. And it is somewhat confused, to my mind, because of the specific lack on behalf of Pakistan, for a number of reasons, of either saying, yes, you can do it, or no, you can't. And so it has therefore resulted in academics, as academics are wont to do, to try and find other reasons other than the simple reason, and that is a state is actually not playing the game that it should be playing in terms of saying either we will allow you to come in and work collaboratively with us, which Afghanistan has done, or whether it's in the situation of being unwilling or unable to act, and therefore the US has had to make steps separately. Of course, once that occurs and you define the use of force in the ad bellum concept, you then have to look at whether or not the level of hostilities are sufficient to cross the thresholds in respect of constituting an armed conflict, whether IAC, all these other forms that are described. And then, of course, becomes an issue of DPH with respect to the application of force in that context. Forgive me for being somewhat reductionist in my approach there as a simple soldier, but that's the bite-sized chunks I find easy enough to digest. I accept that there's some nuances involved there, but from my perspective, in advising commanders, that to me seems to be the shape of the debate, but I'd be very happy to have that challenged in the discussion subsequently. I was very pleased to hear from both the previous panelists comments that UAVs are like any other weapons platform or weapons system. I draw a slight distinction in terms of weapons system and weapons platform, and perhaps it's being somewhat semantic, but in essence, unmanned aerial vehicles are a weapons platform. You can put weapons on them or you can't put weapons on them. You can put all sorts of other capabilities on them or you can't. That's what they are, and they fly around, and they're no different than a B-1B or a ship or anything else for that matter, which is capable of carrying weapon systems and for those to be used, plus a whole host of other systems. They have significant capabilities, but they also have significant vulnerabilities. And in some senses, I find that the whole debate in relation to the use of drones, and I would extrapolate that to the use of technology more generally, is that they are these invulnerable, invincible capabilities which all of a sudden change the entire nature of the war unfairly to the side that's using them. And therefore, they're sinister and bad, and they should be banned. And of course, that's not the case. They have vulnerabilities, one of the most significant ones of which is that invariably there are humans involved in the chain of their operation. And I'll come to that again shortly. Nor is the quest for development of technology and the evolution of technology on the battlefield a new phenomena. Indeed, in fact, the existence of conflict has throughout our history been seen as a significant multiplier to the development of technology. You look at periods of where significant peace exists and then where periods of significant conflict exist. And it's quite ironic to see that the enhancements in technology and the advances of technology are much greater in those areas where you have conflict over a period of time in human history than when you don't. And perhaps that's just one of the ironies of what motivates humans to develop and evolve. The concept in terms of the way in which weapons platforms are used in terms of the UAV debate is also something which I fear has been taken in isolation to the way in which the military use them. What do I mean by saying that? If you look at the way in which UAVs or any other sort of technology is used, it's always used in conjunction with an overarching military plan and military system. And so to pick out UAVs as a specific element in terms of their operation and then to analyze the yin-yang out of that is in fact to fail to accept that they form part of a much broader system and a much broader overarching strategy which the military are operating. And I think it's a particularly false lesson to learn to then say, well, because I'm writing a thesis on X, Y, or Z, or because I want to simply meet the word limit of this particular article I'm writing, I'll just focus on this little thing and only on that. And that is the difficulty, and if I may be frank in terms of my criticism of the academic community, that we have faced in terms of providing us, the military operators, with some useful guidance and advice on the development of the law. Because you read it and you say, well, you know, excellent, some more blue sky thinking. It's a shame that you know, we can't exist up there without some support or understanding of the other world around us. And if I might say, that is a criticism I think that this debate regrettably has suffered from in terms of, or limitations that it suffered from in terms of focusing specifically on one sort of weapons platform or system, and to the effect of not including other elements of the way in which it's operating. The other aspect which I would comment on is that the debate and the consideration of UAVs and the development of technology more widely has been considered in what I regard as a misconceived concept or premise that actually the phenomena in modern conflict is that we have seen a significant increase in the numbers of civilian casualties. I reject that. I don't believe that's the case at all. I think actually the history of the last 60 years has demonstrated a remarkable reduction in the level of civilian casualties which are associated with the conduct of conflict. And indeed, at a conference I attended last week at the Geneva Centre for Security Policy, an eminent British academic, Professor Sir Adam Roberts, who's the president of the British Academy, presented a fascinating paper where he deconstructed an argument which had recently been presented in the British Lancet Journal, that 9 out of 10 casualties in every conflict in the modern phase post the Second World War are civilian, is in fact completely erroneous and built on fallacious information gathering, and in particular definitions of what constitute casualties. And that's not to say that any civilian casualties are tragic. One is unacceptable. But the reality of armed conflict is that you will get civilian casualties, and indeed the law anticipates and provides a framework to accommodate that. So as a consequence, to see the way in which the approach from some entities, lobby groups, advocacy groups, academics, to this debate is premised upon this fact that this simply is part of the general argument about civilians and more civilian casualties than our military. It's just another means by which the military save themselves and provide more civilian casualties, or provide for more civilian casualties, etc., is entirely wrong and wrong-headed. And regrettably, for a military person to say that, unfortunately, invites the hype and hyperbole which is often associated with us saying, well, look, we don't kill that many civilians, and actually by comparison it's not that bad. And of course I'm then seen as the, you know, baby barbecuing monster. So it is very refreshing to see that an academic of Sir Adam's standing has actually entered the debate and in fact put it in a very neutral manner, if indeed you can put the context of any death or suffering in a neutral context. So what I would also add to that is that this issue of risk and the acceptance of risk is something that modern armies embrace. And quite apart from his interview without coffee that he's going to have with the US President, General McChrystal's tactical directive that was recently issued is an extraordinarily brave measure of command, which, for those of us outside of the US military, welcomed with open arms, because it's the first time that a senior United States combatant commander, and I know that's a term of art, or a theater commander, actually told his command, and albeit it was a multinational command, but we're under no illusions that his audience was the US within that chain of command, that you have to accept greater casualties. You have to accept greater risk, which means potentially greater casualties, in order to make sure that we can achieve what our mission and operational objectives are within Afghanistan. Now, no one else but a US general who's got a special forces background, or chicken strangling background, as we would say in the British military, could actually articulate that and achieve effect. And it's incredible, particularly given the maelstrom that was then developed within the US following on from that statement. It was a particularly brave statement, and one which I know allies certainly thought an extremely positive and important development in respect of this whole concept of how we go about accepting risk on the battlefield for our own forces. Having said that, I will quickly cover 2 points today. The first one is some of the legal implications which come from the use of emerging technologies in terms of standards, and secondly, the issue of autonomous weapon systems. Now, I don't offer any solutions. What I would offer is, from a military practitioner's perspective, a number of questions and a number of thoughts, which I would very much hope we could then open up to debate and discussion in the remaining time that we have available. And I'm mindful of the need to try and reduce my time accordingly to facilitate that debate. So what are the legal implications from the developing technologies, particularly with respect to weapon systems or weapon platforms, for us in the military? And of course, here we're not just simply talking about drones. We're talking about a whole range of evolving and developing technologies. Interestingly enough, there's an article written quite recently by an eminent professor of law at Harvard University, who's an ex-legal advisor in the Israeli Defense Force, Gabriela Blum, who discussed this concept of what she refers to as the common but differentiated responsibilities under IHL, which has evolved as a result of the developing technological capabilities. You can, therefore you must argument. In some senses, the military response to that is simply to say, well, that's the way it goes. That's the reality of war. We're always trying to enhance our abilities to get the advantage over the enemy, and this is just a natural consequence of that. And indeed, the entire debate should be shaped in the context of military desire to achieve surprise, economy of effort, preservation of force, but where there's an additional advantage of having enhanced distinction and reduction of collateral damage. However, Professor Blum does mention that there are some calls, whether they be from advocacy groups or other special interest groups, to reassess this standard, which applies to the targeting particularly, that is enabled by the advanced technology, the enhanced targeting. And she draws some parallels in terms of the differing standards that apply in international environmental and international trade law as means by which those countries that can have a higher standard over those countries that can't. But to be fair to Professor Blum, she also says that it is difficult in the military context to actually articulate a specific model which could be applied to put into effect those differing standards, assuming they actually do exist. However, she does make an effort to try and provide a model, and a large part of her article talks about how that might be constructed. Now, as a military officer, I must say I was troubled that she had the need to actually think about that, quite apart from the need to publish or die, which seems to be the mantra within universities nowadays. I'm pleased that Professor Schmidt here is in fact here today instead of off either writing an article or watching England lose. He's probably one of the greatest advocates of the publish or die approach. But it does trouble me that actually those thoughts are in existence out there, that in fact the quite simply understandable military aspiration to increase your edge using technology, using in fact the old, mind abilities of one's reasoning and logic, which of course the concept of effects-based approach to operations is all about, is quite troubling, and in some senses it demonstrates a lack of understanding of the systematic approach that the military have with respect to the conduct of military operations. And if I were to make a criticism of the Philip Alston report, it would be in the context that I think on their section when they talk about the use of drones for targeted killing, or where he does that, it is again somewhat this myopic view of a particular weapons platform and its operation on the battlefield. And I have some concern with that, because it does lack an analysis of the broader integrated approach that these weapon systems have. I mean, it is not the case, weapons platforms I should say, it is not the case that we have large numbers of Predator or Reaper flying around in Afghanistan available to be used. I remember being the chief legal advisor of ISAF in 2006 and 2007, where I stood in the target support cell and had to be involved in targets being called off on many occasions simply because we didn't have predator coverage, which was necessary in order to meet the IHL requirements which we had at the time in terms of discrimination and proportionality. So, you know, it needs to be seen in terms of a broader context, and that's a criticism I would make. The other aspect I would mention is that the nomenclature that is used, targeted killing, and indeed I think a colleague who spoke first mentioned the issue of targeted killing by perpetrators. I found actually not to be neutral language at all. Highly inflammatory, certainly from my perspective, because I accept I have been involved in many killings which have been targeted and provided legal advice on them and satisfied myself so that I could advise the commander that such killing was indeed legal. I didn't regard myself as a perpetrator in those circumstances, and I think that's one of the problems of using this language of targeted killing. That's not neutral even in itself. We talk about targeting, and you target people you are lawfully entitled to target, or you don't. And if you muck up and target people who are not lawfully entitled to be targeted, then the consequences flow from that, whether they be from if they're incidental, or if in fact it's just simply a mistake. So, having said all that, the theoretical discussion of the issue of whether there's a higher standard or not, in one sense, as I can live with. But I found myself cringing then when this little slippery bugger came along. And the reason I say that, and it's my copy, Charles, I haven't nicked yours, because it's heavily dog-eared. And the reason for that is because if you look at, and I'll be very brief in this, if you look at Chapter 9 of the Customary Law Study, it sets the groundwork, essentially, for this concept of common but differentiated responsibilities or standards. And that is deeply, deeply troubling. And I'm going to see if Nils is here at the moment, but I know I've spoken to him on a few occasions about this and expressed my great concern that the direction where an organisation like the ICRC, who has a unique and important role within the development of IHL, almost crosses into the dark side, as we would say in the military, and becomes an advocate or special interest group. And I think it really is a chapter too far in terms of the way in which they articulate where the law is at the moment. So quickly then turning to the issue of autonomous weapon systems. And really, this is a debate which is not commonplace at the moment within the legal community. There are some articles being written on it, and indeed 2 years ago, February 2008, RUSI, the Royal United Services Institute, conducted a one-day conference on this issue. I know Professor Francoise Hampson spoke at that conference. And in many respects, it is a debate which focuses on where the parameters of technology are taking us, and in particular the use of automated and autonomous weapon systems. And one needs to draw a distinction between the two, a very important distinction between the two, because automated weapon systems will perform in accordance with a certain set of parameters being triggered. Autonomous weapon systems imply a degree of reason and logic being exercised by the machine. Now, of course, we have many automated weapon systems in use at the moment. The Phalanx close-in weapon system, cruise missiles, and indeed Patriot missiles are all examples of automated weapon systems that respond in accordance with a certain set of parameters being met. Regrettably, I think there must have been a slight technical problem in the Patriot missile hardware, because it seemed one of those criteria was whenever they saw a Brit. But of course, as a nation that suffered from the consequences of using these automated weapon systems, I have a visceral discomfiture, shall we say, in terms of the extent to which the parameters of the use of these sorts of weapon systems lie. And by one example, if I may just quickly refer again to the conference that I attended last week, run by the GCSP, where a very clever man called Professor Ron Arkin from the Georgia Institute of Technology, I'm not sure if any of you are familiar with his work, but he's a scientist, or as he would regard or call himself, a roboticist, which I think along with hacktivist is another great contribution the US make to the English language. But he has argued that the development of technology is such now that we are now looking at a situation where we can program ethical code into weapons systems such that they can perform in a manner which will allow them to consider the, not just simply the responding to a set of conditions, but also reason and apply logic in terms of operating autonomously on the battlefield. Now, having said that, I am aware that there is some guidance in existence out there, and the US Air Force published the Unmanned Aircraft Systems Flight Plan, which is not just simply a means of getting from Los Angeles to San Francisco, I understand, from over 2009 and 2047, which addresses the developments of UAVs. And importantly, as part of that flight plan, it talks about the authorizing of a machine to make lethal combat decisions is contingent upon political and military leaders resolving legal and ethical questions, which I found quite gratifying and very satisfying when I read that. Indeed, it talks about a man being in the loop at every point in time. But unfortunately, the debate has evolved, and the roboticists, shall we say, have now started evolving the debate, and indeed there's some military people talking about it simply being a leader in the loop as opposed to a man in the loop, which to my mind raises questions as to accountability and responsibility in terms of the operations of these systems. Of course, the main concern is that we as the legal community are not left behind in this debate and make sure that we are able to inform and shape the debate as it goes along. And clearly this seems to be a case of finding the permissible boundaries in which technology can expand to and that we are happy with. And in some senses, the Article 36 obligations in terms of weapons assessment is perhaps the most appropriate vehicle to achieve that. But of course, that won't involve a broader debate in terms of the use of these type of weapon systems outside of that particular military. In addition to that, if you look at the number of UAVs that are being developed, UAVs, I beg your pardon, a number of emerging technological developments which are occurring around the world, I am not satisfied that the People's Republic or the People's Liberation Army of China, who's currently trying to develop stealth drone technology, or in India, or in the Russian Federation, or in Iran, or other countries around the world, have a sophisticated Article 36 weapons analysis process which will take into account all of the legal issues, and I find that quite troubling. So my final observation then would be that quite apart from the legality of the use of these weapon systems, or particularly autonomous weapon systems and their evolution, and I know Professor Schmidt will disagree with me on this because he regards ethics as being something a matter for priests, but I find it concerning that an action which is inherently human, and that is the conduct of hostilities and armed conflict, is potentially being reduced to the level of algorithms and automated robotic actions, and that process removes from us our ability to evolve and develop as a human race as such, in terms of accepting that there has to be limits on the conduct of warfare and the conduct of hostilities, and that in fact in many respects may indeed give nations a perception or a view that it is easier to conduct them because we can just simply subcontract, not to the PMSCs this time, but to the robots. And I find that a very discomforting and unhappy position to be in. I'll leave my comments there. Thank you.
Operating. Thank you, Darren. Pete?
Thank you, John. I'll try to be as brief as possible. First, I don't thank Dennis for putting me on this panel. I went away on a trip and I came back. I was supposed to be the moderator and found out subsequently to my trip that I was now a panelist on this panel. But it does assist me in preparation for the elective that we teach here at the War College on Unmanned Systems that John Jackson puts together, and I participate in providing a block on that. I'm not gonna use the slides because we really don't have time. Maybe at the end we'll put my last slide up, which may be entertaining. Also, I apologize for not having my coat on because Dennis told me I couldn't wear my Hawaiian shirt today. I just came from Hawaii last year, and my wife said she was cold, so I gave her my jacket, and I noticed that she doesn't have it on anyways. So I could have worn my jacket and been more presentable. But let me try to address some of the points that were raised by my colleagues. First of all, Hina starts out by indicating Professor Alston's interpretation of his mandate as the special rapporteur. I would suggest that his broad interpretation of his mandate is part of the problem. Clearly, the General Assembly resolution that created the position of the special rapporteur in 1982 did not give the special rapporteur any competence over the law of armed conflict. Similarly, when the Human Rights Council was created to replace the Commission on Human Rights, there was nothing in that resolution that granted the organization any competence over the law of armed conflict. So therein lies part of the problem in the professor's admonitions to the U.S. government that we are somehow not being upfront in responding to his allegations in his report that was filed with the UN. And I'll return to that in a moment. But now we look at the 2002 report that was issued with regards to the al-Harithi incident in Yemen in 2002. And again, we see the special rapporteur indicating that this was a clear case of extrajudicial killing in violations of international human rights law as well as international humanitarian law, even though the strike had been authorized by the Yemeni government. Al-Harithi had planned the Cole and the Limburg attacks. Prior attempts to apprehend him had been unsuccessful, and an acknowledgement that governments are responsible to protect their citizens against terrorists. So despite all of those findings by the special rapporteur, the decision was still made that this was a clear case of extrajudicial killing. Now, the U.S. did respond to that, and I would suggest that Professor Alston's complaints that the U.S. is being evasive with regards to responding to his request for information are not so much that we're being evasive, but he just doesn't like the answers to the questions that he's receiving. The U.S. did respond both to the 2002 situation as well as to requests from Professor Alston in 2004 or 5, I believe, where the U.S. government did indicate that that military operations, in particular targeting decisions, are issues that are governed by the law of armed conflict and are outside the mandate of the special rapporteur. These issues are governed by IHL and not by international humanitarian law. If you are targeting an enemy combatant, clearly that is lawful under the law of armed conflict and is not an extrajudicial killing or an assassination under the U.S. domestic prohibition on assassination. So let's see, what else we got here. Also, I think Hina indicated that there's less risk to soldiers involved in using drones, and that perhaps is maybe lead to U.S. Personnel perhaps not applying the law of armed conflict the way that they should. I disagree with that. I think it's a good thing that there's less risk to our soldiers, as again, we'll return to that at the end of the presentation. Now, the Professor Alston's report also talks about how the CIA should not be involved in these operations, and calls a halt to the CIA. I believe, Hina, you indicated that it's because the CIA was incapable of complying with international humanitarian law or the international human rights law. and that there was a lack of transparency in what the CIA was doing, and that the military was more inclined to comply with the law of armed conflict. Now, I would suggest, I've been involved in small targeting cells for capture-kill missions where we've had a CIA liaison in the cell, and I would suggest that they are very aware of what the rules are very cognizant of the proportionality and distinction principles under the law of armed conflict, and are very capable of complying with the law when it comes to these types of operations. So again, much of the information that the professor would seek is classified information. We're not going to divulge our rules of engagement. We're not going to divulge our sources of intelligence, particularly if we're talking about a human source that may be in the camp that we're going to hit. So much of what's being requested simply is not available to be provided. So to even request that information, I think is somewhat disingenuous, because he knows that he's not going to be able to get it at the end of the day. And with regards to, again, the criticism of, or one before that, the issue of consent of the state before you can use force in self-defense. I think it's widely recognized state practice that self-help is an appropriate remedy if the state where the threat is emanating from is either unwilling or unable to neutralize that threat. In the case of Pakistan in particular, we've seen Pakistan either be unwilling in the sense that because of the remoteness of the location of where the terrorists are operating from, they are unable to neutralize a threat, or are unwilling to neutralize the threat because in large part the Pakistan Taliban has focused their efforts in Afghanistan and not in Pakistan, and therefore there is somewhat of a reluctance on the part of the Pakistani government to engage the Pakistan Taliban, although that may be changing, but they do so for selfish reasons, because they don't want the Pakistani Taliban then to turn their attention to their own country. So whether consent is required or not, I would say that it is not in the situations where the state is unable or unwilling to neutralize the threat. And finally, the professor's criticism of the ICRC interpretive guidance with regards to the continuous combat function is, again, one, I don't think the ICRC interpretive guidance is a good first step. It's a package deal, and as a package, it is deficient, and therefore it's not a good first step by any stretch of the imagination. And secondly, then the professor's position that perhaps it's incumbent on him and human rights organizations to have the lead in determining what should be direct participation in hostilities. And the reason I would say that is the report suggests that perhaps the commissioner for see if I can find it here. Yeah, it's as Hina said. The suggestion is that that a neutral body should take the lead in this debate rather than having the ICRC coordinate these efforts with state parties. And again, I think that's an overreach on the part of the special rapporteur. And I would just like to read something to you. To me, the folks that advocate that human rights law should apply in an international armed conflict scenario are really making the argument not for the purposes of protecting, adding additional protection for the civilian population, but rather in order to gain more scrutiny over military operations. I'll read something to you. It goes, "We wish to boldly take human rights to places, be they extraterritorial situations or those of armed conflict, where as a matter of practical reality, no human rights have gone before. The purpose of the IHRL project is the enforcement of IHL through human rights mechanisms. Thus, even if human rights substantially adds nothing to IHL, there would still be a point in regarding IHL and IHRL as two complementary bodies of law. IHL, now jurisdictionally framed in human rights terms, could be enforced before political bodies such as the Human Rights Council or UN political organs more generally, or through judicial and quasi-judicial mechanisms such as the International Court of Justice, the European Court of Human Rights, etc. Again, so if you agree with the premise that human rights law adds nothing to the protection of civilians because IHL is more protective, then it becomes an issue of the human rights advocates want to enjoy greater scrutiny over military operations. And I think that's a bad thing because I've never read a human rights report that is pro-U.S. military or pro-Israeli military. They seem to be extremely critical while failing to recognize or failing to acknowledge the fact that terrorists engage in a greater number of civilian deaths than do the military organizations. So it just provides an additional avenue for terrorists to get these reports and use them in their strategic communications campaign against the coalition operations. So I think that's a bad thing and not a good thing. Turning to Ken's comments, I agreed with really with virtually everything that Ken discussed. I don't know that I agreed with him, though, on what he, at the end of his presentation, where he talks about how the current administration is moving away from the concept of a global war on terrorism. I think that perhaps the nomenclature has been changed, as we saw with Bobby Chesney's presentation yesterday, where on the detainee ops, where you add one additional word to the who can be detained. I think we have a nomenclature change here. They might not be calling it the global war on terrorism, but surely I think you would agree that even under Coe's analysis, that if there is a threat, regardless of where that threat may be located in the world, that the U.S. enjoys the right of inherent self-defense and can take lethal action against that threat. So to me, it's not so much a moving away from the concept of a global war against terrorism, but rather a change in nomenclature to appease political discontent with the prior administration's policies. Now, I agree with Darren's presentation. I'd just say that on the issue of reduction of number of civilian casualties, I think that's true. I think there's a lot of reports out there that are not based on fact. A lot of the opponents to the use of drones will argue large numbers of civilian casualties, and that because of that, let's say a ratio of 50 casualties, civilian casualties, one terrorist killed, that somehow violates the principle of proportionality, or somehow violates the principle of military necessity, because the family members of those casualties then become Al-Qaeda sympathizers, etc., and we are therefore not achieving our military objective, and therefore killing these individuals has no merit and no military necessity. Again, there was an independent study that was conducted by the New America Foundation, which indicated that there was that there was a significantly less number of casualties, civilian casualties caused by coalition operations, only 30% as opposed to 70% that were being caused by Al-Qaeda and by the Taliban. There was additional reports that were published by another independent organization from Pakistan itself. Which again indicated that those casualty figures could be as low as 20%, and U.S. Intelligence estimates have it as low as 5%. If you look at who are the casualties, you're talking about are they voluntarily present with the targeted terrorists? Are they actually sympathizers? Are they voluntary human shields, in which case they would be directly participating in hostilities and could be engaged? So a lot of the figures that are being quoted as the civilian casualties don't really stand the test of independent research. And I think we're running out of time, so let me stop there and we can take some questions.
Thank you, Pete. I am going to turn this over shortly to you folks in the audience for your questions and comments. But Hina has asked for an opportunity briefly to respond to Pete's criticisms, and I think that is fair and correct, but please make it as brief as possible, Hina.
I will do that. Pete, thank you for engaging on this. Let me start with the couple of areas in which we agree and where I'm afraid that I might have either been misunderstood or misinterpreted. Very emphatically, the existence of less risk to armed forces is something that I think we absolutely agree on, and I really hope that there wasn't anything, and I don't think that there was anything that would give the impression otherwise in my discussion. We also agree about self-help. The report very specifically says that in the context of the exercise of force extraterritorially, where states either fail to prevent attacks on the targeting state or are incapable of doing so, then, in this situation with respect to Pakistan, the United States would have a very good, reasonable basis to argue that what it is doing is proper. I'm not going to engage extensively on your criticism and the criticism made by the United States, which, again, I'm hoping has been, withdrawn by omission with respect to the mandate of the Special Rapporteur and the UN Human Rights Council, except to note that to limit that mandate would put out of consideration some very difficult, dangerous situations occurring around the world, including armed conflicts around the world where there are gross, massive human rights violations occurring. And I don't think that as a matter legally, but very much as a practical and development of law matter, that is a good idea. The thing that I really do want to talk about, which is, I think, a harder question, is what is required by transparency and disclosure. And it's one that I don't, have a very good answer to, in part because discussions like this don't happen often enough amongst those calling for disclosure and those saying, here are the problems with the disclosure. Let me say what is not at issue. One is, I think it's too easy to say calls for disclosure, risk disclosure of classified evidence, and sources and methods. Let's just acknowledge that there's a very reasonable basis for nations to withhold that kind of information, to withhold rules of engagement. That doesn't mean, though, that there isn't a larger, broader source of information about which doesn't implicate sources and methods and classified information, about the category of people who are being targeted, the scope of the conflict within which that targeting may occur, as well as procedural safeguards to ensure that targeting decisions are correct and are followed up on. Very, very quickly, I had a very brief conversation with General Dunlap during the break, talking about a really useful conversation I had at a conference at the National Defense University, talking to one of the senior airmen out of Creech who do targeted killing operations. And I say to Charlie Dunlap, you know, this guy should be out there front and center, and policymakers should be making these decisions, which is, you know, he was able to say, look, we have pre-action review, we have after-action review, here are the processes that we have set in place. He wasn't disclosing classified information to me, he wasn't disclosing secret information to me, but he was making the case of policies and procedures that exist that give us comfort that what is being done is legal. And I think that's really the starting point for our discussion, is where we can go with that, what can be disclosed. The report discusses some concrete things that would be called for in terms of types of disclosure, which we can get into during Q&A, but let's just take off the table intelligence and sources and methods, because that's just too easy to criticize things with, and let's have the more difficult discussion, which I think is the necessary discussion to have.
Thank you, Hina. You did keep your remarks brief, and we appreciate it. Well, ladies and gentlemen, let me open it up to your questions and comments. We have half an hour for those. I would ask that you keep your questions and comments brief, so as many people as possible will be able to participate in the discussion. Thank you.
Charles Cogan, Kennedy School, formerly Chief Near East South Asia in division in the Operations Directorate of the CIA, particularly during the period of the war against the Soviets in Afghanistan. I'd like to pose the issue of why the CIA is involved in sending drones from Afghanistan into Pakistan. There may be a technological aspect to this, in that the CIA may have developed drones before the U.S. military. I don't know what the answer to that is. But there is, in addition, there is an operational reason, and that lies in the relationship between the CIA and the main Pakistani intelligence service, the ISI. And it goes back to the 1950s, where the U-2 plane, which was developed by the CIA, had its jumping off point at Peshawar. And therefore, this necessitated a relationship between the CIA and the ISI in order to coordinate these flights. Now, normally, the CIA is in touch with the civilian intelligence counterpart in a foreign country, but this was a unique situation. The CIA is in touch with the ISI, and this relationship remained for years and years through all the ups and downs of the political difficulties between the United States and Pakistan. And so, obviously, although there are many questions about the ISI and its former members or present members who may have sympathies with Gulbuddin or Haqqani or others inside Afghanistan, nevertheless, it's unquestionable that these drone attacks are carried out with the coordination of the ISI. And that's sort of the reality on the ground that I'd like to bring to your attention.
A question, George Walker, Wake Forest Law School, a question about overflights of third states and, if you will, overflights of signals of third states. And I think about, first of all, in the self-defense context, and number two, in the LOAC context. What views on that?
Well, I guess the question that I take out of that would be the question of whether, what the issue is of sovereignty of the state where the overflight is taking place. And I guess I'd say the general legal principle is that territorial sovereignty is really, really, really important. And at the same time, it's not as U.S. legal advisors have said for a very long time, State Department legal advisors have said for a very long time, it's not the only principle at issue. And so, as we've stated repeatedly here, where there is an unwillingness or inability to control one's territory, then that presumption of territorial sovereignty may be overcome. And that's true, including the use of force, but I would assume that under various circumstances that could include overflight and surveillance and lots of other activities that are short of actually using force as well. There's no question that it's a violation of sovereignty. The question is whether that violation of sovereignty can be, whether that presumption of sovereignty or that rule of sovereignty can be overcome in some fashion by some claim of self-defense about third-party actors that are not being controlled in some way.
An aspect which more or less follows the question by George Walker. I agree with Darren, Hina, Ken, that there is no prohibition under the armed conflict to make use of civilians in the battlefield. And it would also hold true for civilians operating a UAV, if and only if a UAV is what you consider it to be, meaning just a weapon similar to a missile or a gun or whatever. However, you all know that we have been struggling to have others accept that UAVs qualify as military aircraft. And I may remind you that under the law of air warfare, only military aircraft are entitled to engage in belligerent acts. And if that is true, and if a UAV qualifies a military aircraft, then certain conditions must be fulfilled. And then a UAV operated by, for example, remotely controlled or pre-programmed by somebody who is not a member of the armed forces, may make a UAV, at least there could be claims to that effect, a UAV an unlawful means of warfare, because I just would like to remind you that an aircraft that is not marked properly as a military aircraft would not be entitled to engage in acts to the enemy. And it have implications for time users of UAVs. Now, I wouldn't say that a UAV loses its sovereign immune status if it's not operated by members of the armed forces. However, there could be states claiming that if an UAV is operated by civilians, then they would not be prepared to accept their sovereign immunity, and they would reject any claim for passage rights, for example, over an international strait or over archipelagic sea lanes. And this may also have then repercussions on unmanned seagoing vehicles. So in short, you cannot have it both ways. If you want UAVs to qualify as military aircraft, then you must take the consequence. And if you don't, well, then you will really get into trouble by counterclaims of others.
Yes, I have a question specifically for Professor Anderson. Thank you for your really masterly categorization of the arguments that we find in this area. I wondered if you would be willing to continue your categorization by addressing the question that you saw that Harold Coe raised with respect to there being a third area for the use of force. Particularly you mentioned covert CIA operations, and his comments that yes, they were subject to some principles of law, a somewhat indeterminate statement, but would you categorize for us what you would expect the criticisms to be of having a third area for the use of force, and also the criticisms that you would expect to arise with respect to what law would govern those uses of force?
Thank you. I think that's a very important question. One thing that should be said, of course, about Legal Advisors Co's statement was that it was about 4 paragraphs, and so although it is very important in the sense that it is stated as the considered view of the U.S. government and hence carries that kind of legal weight, I think that it is actually the opening of a legal analysis rather than anything that can be considered more than what you can say in a few paragraphs. And Hina probably would have more to say in the form of what the criticisms would be, but let me take a sort of initial shot at it. The assumption that underlies it is that you don't wind up thinking that all uses of force are either law enforcement or armed conflict. And if one goes back to the 1980s, Hayes Parks's writing back in that period and numerous other people within DOD and other areas, there is actually a lot of discussion about various kinds of uses of force that do not rise to the level of armed conflict and various kinds of rules that apply to them, and there's discussion about various kinds of operations that don't actually involve counterterrorism and the kinds of things that we're talking about now. And in that sense, I think that the legal advisor's statement sees itself as being continuous with a U.S. legal view that goes back a very long way and is not actually an innovation on its part, but in fact is reassociating itself with a much longer-term view of the U.S. government on the nature of self-defense. That said, if you have some form of use of force that you are essentially categorizing in a jus ad bellum sense, that there's an ability to use force in ways that involve going after non-state actors and so on, then any use of force has to have some set of legal standards that apply to how it's going to be used. And that, so to speak, goes with the territory, and the question is, what are going to be the principles underlying that? I think that one of the criticisms that would be a very fair criticism to make of this would be to say, aren't you really simply looking to avoid all of the technical rules worked out in the law of armed conflict for the use of force by invoking this kind of vague self-defense thing that's got simply a bunch of vague principles attached to it but don't really bind you to anything? Isn't this really a sort of end run around the vast body of law which has been developed technically to govern use of force in armed conflict? I think the response to that would be that is always a risk, is always a danger, but that much of the technical body of rules that has been developed is itself extraordinarily focused on state-to-state warfare in an overt conventional sense. And one of the problems about this is that the attempt to redefine these rules around things like, say, Ryan's invocation of the Padilla situation yesterday. Ryan's invocation sounded one way when one was thinking about it on a conventional battlefield. As soon as it was said, oh, and he's stepping off the plane from O'Hare Airport, then the framing of that issue suddenly makes it seem like a really different thing. And I think that that limitation actually applies as well. And so what I think comes out of that is you don't need to see this as being a lessening of the standards, even though one is shifting from detailed rules worked out for overt conventional battlefields and state-to-state encounters, that if one shifts to a self-defense standard, one is not necessarily lowering those standards by saying that the general rules of necessity, distinction, and proportionality still apply. In particular, I think one of the things that the legal advisor is acknowledging is, and this I believe is the first time that something like this has been said publicly by someone of that level within a leading government, that the standards are not going to be able to be lower than what the equivalent military operation would be, and that actually is the implication, that even if it's a principle, it's not going to be able to be lower than if the military were itself carrying it out in terms of things like the levels of acceptable collateral damage and the rest. Indeed, I would suggest, I don't think that this is at all raised by his comments, but I would suggest that insofar as one is talking about uses of force which are intended to be intelligence-driven, high-value targeting of the kind that the CIA has been tasked with in at least part of its work, actually requires a higher standard in the distinction category there. That is, one is going to have to make a better identification than would normally be the case if one were dealing in overt on the battlefield conventional war, where one is able to deal with simply an undifferentiated mass of acknowledged combatants that one can strike at will. Where one is going for intelligence-driven killing in that sense, then I think that the standard that applies in distinction may actually be a higher one rather than a lower one.
Yes. No, I'm sorry.
Thank you. It's a question on automated systems, so I guess it's for Darren, but others may want to comment. And it's about the issue of responsibility. It will be relatively straightforward to operate a system of civil or state responsibility, but do you think that the law of armed conflict requires that there must be a realistic possibility of criminal proceedings if necessary, in other words, a human agent? And do you think it's realistic to regard the possible prosecution of the computer programmer as sufficient for these purposes?
Yeah, that's a very difficult area. I know it's the issue you discussed at the RUSI conference, and my notes in relation to your comments are in my briefcase. I don't want to regurgitate them back to you, Francois, but yes, I don't believe that the concept of using a state responsibility mechanism is sufficient in relation to governing the actions of autonomous weapon systems, and the reason for that is because it, in many respects, goes against what the entire premise and focus of having the legal paradigm, which is the jus in bello, is about. So I have problems with that, and it troubles me that you don't actually have a trigger puller per se in an autonomous weapon system that you can attribute blame or accountability to. I think the computer programmer is too far removed. And will produce code in complete isolation and ignorance, potentially, in some circumstances, of how that code's going to be used and incorporated into a weapon system. The concept of the leader in the loop concerns me, because we all know now that the concepts of mission command are such that commanders at varying levels will give an intent of what they wish to achieve and allow for freedom of action of subordinates within that. I understand the whole issue in relation to the debate on autonomous weapons systems as those advocating for their development, or at least debating about their implementation is concerned, say that they're complementary. They exist on the battlefield at the same time as humans will exist on the battlefield. And although that doesn't answer your question, because if you have a platoon of soldiers or a section of soldiers who are dug in, or patrolling, doing an activity, and you have this autonomous weapon system that all of a sudden just goes off on its own, and then turn around and think, well, are we jointly liable in relation to the actions of that or not? So it's a problematic area, and I do have some concerns, and that really lies with the issue of the autonomy aspect of it. And I think that really is where the parameters, I think, are going to have to be drawn unless we can find some adequate answers. Automaticity is and that is an English word, I have to say, because Sir Jeremy Greenstock made that up at the time of the Iraq crisis in 2003. But automaticity is one thing in terms of an automated response. But where you then start introducing this logic code, the ability for this weapon system to perhaps think outside the box, dare I say, is an entirely different matter, very problematic, and one of the reasons why I have concerns.
Can I just add on that point? Autonomous systems raise radically different questions from simply drone warfare and predators flying around. But And I have very mixed feelings about it. Let me recount you a conversation with Ron Arkin on this. I say to Ron, you know, I have a background in moral philosophy, and I have to say, on one hand, I kind of admire this can-do engineer sense that I can incorporate Kant and Bentham all into a single set of code. But I'm not sure that my philosophy professors would have signed off on any of this. To which his response was, you know, I don't actually have to do Kant or Hume. I don't actually have to do as well as any of that. I don't actually have to get it right. I only have to get it as right as you get it. And I'm not quite sure that that's the right answer to that. So I have enormous problems with where this is going. On the other hand, I do have to say, 100 years from now, our concept about decision-making about this may be really, really different. And I say this as somebody that studies robotics a lot in the context of medical robots and elder care robots and things like that, and think we're not very far from the day in which the presumption is going to be that it's malpractice for the doctor to override the computer without some good reason to do it. It would not be impossible to imagine a world in which technology, which we really don't know where it's going to go over the next 100 years, 100 years from now means that the presumption is going to be that it's a war crime for the soldier to override the battlefield machine unless there's some very good reason to do it. So I think we should actually be careful to remain agnostic on this point, with one caveat, which is that I believe the biggest risk posed by autonomous systems is not actually that we get it right in some way. It's that China, for example, will decide that it's right enough if they have a system which doesn't have any greater capability than to simply identify where the fire is coming from and to return fire. We would not consider that to be a lawful system. We would not deploy that on the battlefield. And I think that the bigger risk for us with autonomous systems is that we'll discover that we're in the position of having to deploy counters and defenses to systems that we ourselves do not believe are sufficiently ethical to actually use ourselves. And the response to that usually from the military people is not to worry, we'll just drop a really big bomb on it. We'll just go kinetic. But I think the problem with that is that it's not going to be that kind of system. It's going to be a whole bunch of little swarming bumblebees that will just sort of separate and then come back together in order to do that. The technology will move in ways that will make it really hard to simply drop a big bomb on that system that we don't like.
Professor Murphy. Professor Murphy, could you recognize me, please? It's Colonel Irwin. I've got a comment. And I'd like to make the comment as an American citizen, first of all, as an American airman. I feel compelled, and also just let you know I'm the judge advocate at Joint Forces Command, where the commander is a 4-star Marine, General Mattis. And I just want to address the sort of big picture that's been alluded to, robots and accountability and transparency. On the big picture, I was asked to represent General Mattis at Old Dominion University, a discussion, robots on the battlefield. And Dr. Singer was there, who's written a book called Wired for War. I was representing strategy. A very capable Marine Corps lieutenant colonel was doing law. And I had to prepare for this event in about 2 weeks. And in doing so, I gathered a couple of things. Robots, what are they? And my study led me to conclude that, when David picked up a sling and felled Goliath, he was using a robot. And it brought me quickly to World War II. And as an airman, we have to look at World War II and what decisions were made in the war in the Pacific. And that led me, to really dwell on the Air Force, Strategic Air Command, and just how Strategic Air Command had functioned for many years. So the big picture question I would throw into the debate is UN Security Council Resolution 1887, which is the nuclear non-proliferation resolution. And I would just throw that out there, read that one. And then on robots, there are a lot of duties. And so we have to make sure we're educated and trained within the military. That was the other conclusion I came to in our robots on the battlefield discussion, which was held by the philosophy department at ODU, interestingly enough. Then finally to accountability and transparency. Yes, there has to be a human accountability for actions, without a question. And in the U.S. military and the Judge Advocate General's Corps especially, we are always on the hook for justice, as well as ops. And so we deal with this every day. And finally on transparency. Is transparency being sought with Al-Qaeda? And I recommend you to Bodansky's book, The Man Who Declared a War on America, Osama bin Laden. It's a great 30-year study of Al-Qaeda. And, when we're asking about transparency and truth, I think we ought to ask, what's the truth about them? No further comments from me.
Hey, John, there's a colleague from Pakistan here who's been trying to raise his hand.
I think we can entertain probably two more questions. First, which gentleman? Gentleman from Pakistan, and then Michael Schmidt.
Yeah, thank you very much. I'm Commander Khurram from Pakistan Navy. I'm doing a course here in Defense Institute of Legal Studies. I have a comment followed by a question, and it will be focused to the use of drone. At present, Pakistan is the only country which is heavily affected in terms of casualties and civilians, including women and children, and affected by these drone attacks. As per the current statistics, it is almost a ratio of 1:50. And so killing of one bad guy is causing killing of 50 innocent civilians. So the matter of collateral damage and proportionality, in my point of view, is greatly compromised. Pakistan had condemned these attacks on all occasions. And I personally don't agree to the comment of Mr. Pedrozo about Pakistan is unable or not willing or not putting the best efforts to fight against the terrorism inside the country. At present, Pakistan military forces fighting the war of terrorism inside the country in the upper part with the Taliban, and we are facing heavy casualties, military casualties. In response, we are already having terrorist bombs attacks inside the country on a number of occasions. My question is this: in this scenario, does Pakistan, being a sovereign state, has the legitimate right to use force against these drone attacks?
Pete, you want to take?
I'd like to address that one.
Well, first, I would just say that I question the, again, as I mentioned earlier, the number of casualties, the ratio of the number of casualties and the number of terrorists being killed is greatly debated, and in one extreme is exaggerated by the Al-Qaeda and the Taliban on the one hand, saying that all the civilian casualties are innocent civilians, over to the other extreme where you have the government agency saying that the numbers is only 5%. So you have the two extremes. So where do you meet? Again, I indicated there's a couple of independent studies that have been conducted which indicate that the casualty rate is more attuned to 20 to 30% of civilian casualties being caused by coalition forces, as opposed to the several 100% that's being claimed by the opponents of the use of drones. So that's one point. Secondly, as a sovereign state, do you have a right to exercise self-defense against an attack by another state? I would suggest that the attacks are not being conducted against Pakistan, as our colleague up here indicated. To a certain degree, that I would suggest that there is evidence that Pakistani government is tacitly agreeing to these strikes, and in many cases providing intelligence to support these strikes. And to say that the Pakistani government has protested these these attacks. While that may be true to a limited extent, there is an equal amount of evidence that shows that it is providing support for these operations. So do you have a right of self-defense? Absolutely. But only against an armed attack against your state. And I would suggest that what these drone strikes are attacking are not Pakistan, but an area in Pakistan that is under the control of the Taliban and by Al-Qaeda. You look at the again the study that was conducted by the Ariana Institute for Regional Research and Advocacy. It asked a number of questions. And one of the questions was, do drone attacks violate Pakistan's sovereignty? Over 2/3 of those responding said no. What the response was, we're not attacking, you're not attacking Pakistani sovereignty. Pakistan lost sovereignty over the Fatah many years ago when Al-Qaeda and the Taliban took control of that area. What you're attacking is Al-Qaeda and Taliban sovereignty, not Pakistan sovereignty. And the other question, who is the #1 enemy in Pakistan? It's Al-Qaeda and the Taliban. That's the #1 enemy. And should U.S. strikes continue? Over 2/3 of those responding said yes, they should continue. And should Pakistan conduct strikes against the militants? Over 70% said yes, they should.
If I could just add just a couple of comments to the response of my colleague on the panel. I understand where our friend from Pakistan, the commander's comments come from, in the sense of often it's the case that nations are not particularly good at communicating their overall strategy down their chain of command to those who are involved in the fight right to the very bottom. And may I draw an analogy, one which might prove a bit discomforting for some of the US people in the room, but we in the United Kingdom for some time were mostly concerned about the extent to which Irish Republican terrorism was being aided and abetted out of the United States of America, Boston in particular, and indeed involving people that could extend quite high up the United States government. And we'd love dearly if on occasions to throw a tea lamb at some parts of Boston, not purely in relation to getting back for the loss of tea. But the bottom line is that those of us who were fighting in the province and across the UK and other parts of Europe where we're being targeted by terrorists were not being told that the strategic position, although we could work it out to a certain extent, the strategic position was for the United Kingdom not to go and poke the US in the eye and say, you know, sort this out, largely because we probably couldn't reach up quite so high in the David Goliath scenario. And it created enormous frustration and enormous I think discomfort and unhappiness within the militaries generally. And I think that is playing out again here in Pakistan, perhaps a little bit more overtly, in the sense that you actually do have potentially US agents operating within Pakistan, effectively killing not only Pakistani civilians but potentially combatants involved in this particular conflict. And I accept that Pakistan is definitely making a significant contribution to try and deal with the terrorist threat within its borders. And I reject US suggestions that that's not the case. And in fact, that's the official position of Her Majesty's government as well, that Pakistan is making significant efforts to try and reduce the terrorist threat within its borders and suffering significant casualties as a result. So in that sense, I can understand your frustrations and concerns and those of the Pakistani community generally. But the reality, I think, you can draw as from a conclusion, from an analysis of what's happening on the ground, is that there is a position that's been taken by the Pakistani government, probably based upon whether they're wanting to pick a fight with the United States or not, whereby they are prepared either in one sense to be tacit and allow for these to occur, and express concerns privately, or, as has been suggested by some people, to facilitate those strikes. I'm not sure which of those areas is the case, and I'm not suggesting one or the other. But I think, you know, that debate needs to be understood, and the whole question of Pakistan's involvement in dealing with the terrorist threat within its borders, I think needs to be articulated in a little bit more accurate light than it perhaps is at the moment. And I think there's quite a lot of a fairly biased presentation from certainly within the US about the level of commitment.
Was willing to waive, but if you want to have me ask the question, I will, and it's to Ken. Ken, I'm a little troubled by the by counterpoising self-defense and armed conflict, because self-defense is a jus ad bellum concept, and armed conflict is a jus in bello concept. It seems to me that if you have self-defense, you may have self-defense in a armed conflict that is international, at least theoretically non-international, or has some can have argued in something other. So I just wanted to catch your views on whether or not is that really the right comparison. Shouldn't the comparison be international armed conflict, non-international armed conflict, and then if you're one of those who accepts some other state, whatever, transnational armed conflict, and then criminal law?
The one line, I'm not even going to try to answer that question. It raises, of course I'm going to try to answer it. It raises a really crucial question about the relationship between self-defense and its aspects as a jus ad bellum concept, but a jus ad bellum concept that has to have some jus in bello standards for its application. And then the question of armed conflict as a jus in bello state of affairs, so to speak. The way that I would frame self-defense is that the large circle is self-defense, of which armed conflict is a part, but armed conflict doesn't exhaust all of the ways in which force can be used, and that armed conflict, as we use the term, is a jus in bello term, but it has a correlating jus ad bellum, you know, whether one describes it as belligerency or some other term like that, that corresponds to the jus ad bellum side, and that self-defense is the same way, but that in fact the larger category is self-defense into which armed conflict falls within it. I'm not unhappy with the idea that maybe one should apply an entirely different set of terminology reaching somewhat the same kinds of results, however, but I don't think that's traditionally where the U.S. has been in terms of how it's framed it.
Well, ladies and gentlemen, please join me in a round of applause for this very good panel.